Hi, this is Jen Rubin, editor-in-chief of the Contrarian. We have back with us Andrew Weissmann, former General Counsel of the FBI. Andrew, good to see you.
Nice to see you.
So this week, James Comey was arraigned in federal court. Now, sometimes these things are very uneventful. They just enter a plea and they set some dates, but we found out a bit about their strategy. What did we find out?
So, I was taken aback by Jen when just the statement um, this week, James Comey entered a plea of not guilty at an arraignment.
Yes.
Just that statement alone, you would think, and this is going to answer your question, you would think this is so momentous. You are indicting the former general counsel. I'm sorry, the former, sorry, that
Forward.
says because I'm thinking of myself. So, in sort of my role, the former director of the FBI, and so you would really have your ducks in a row.
Yes.
You would put your best people on it. You would have really spent a lot of time thinking about the evidence, and you'd be prepared, and you'd have all the discovery ready to go, and you'd be like, Judge, we're ready to go to trial. You're in the rocket docket. The government is typically the one that wants to go to trial. Defendants are typically the ones who say, I never want to go to trial. There's a
Yeah.
famous Edward Bennett Williams quip, which is, for a defendant, any adjournment is an acquittal, meaning just put any day that you're not going to trial is a good day. So
Yes.
that's the norm. This was the reverse. So
Yes.
here, what we learned is the government is just getting their arms around discovery because the two people on the case, the two prosecutors, are not in the Eastern District of Virginia, the case where that is where the case is. And normally, not even normally, that is the prosecutors in that office bring those cases. Well, none of the career people, as the reporting is, would be on the case. And so they had to go to a different U.S. attorney's office, which means these people do not know the case at all, which is why the junior person on the case tells the judge, we're just getting our arms around the discovery
Right.
in a case against the former director of the FBI. In
Right.
addition, they did a number of things that made it clear that their game plan is going to be never going to trial or delaying this
Right.
as long as possible. And that is because they're sort of delaying the inevitable. If this went to trial, it just seems so preposterous that they would ever either get to a jury because a judge could dismiss this after the government's case to say there's insufficient evidence, or that they're ever going to find a jury of 12 people who unanimously agree there's proof beyond a reasonable doubt. So the government strategy, we're just getting our arms around discovery. Judge, please declare the case complex under something called the Speedy Trial Act. The government only has certain amounts of time to bring the case to trial because it is supposed to preserve the public's right to a speedy trial. But if the judge declares a case complex, you get more time. So they say, Judge, this is a complex case. And the judge, basically, who has been on the bench, either as a district judge or a magistrate for years, and
Yeah.
is a federal defender, basically is like, I'm not buying like what you're selling.
Exactly.
It's a two-count false statement case. That is not a
Exactly.
complex case.
And they also went through this whole charade that they have all kinds of classified information. The discover no, it's not. They have
It,
like two facts and a
so
witness. That's
So,
it.
and the judge on that was fantastic. The judge says, look, essentially, it is me paraphrasing, I highly doubt that. But he also said, I've been a judge for a while. You want to you have classified information. I know there's this process under the statute called CIPA, which is CIPA, Classified Information Procedure Act. He goes, this will be the fastest CIPA review and process you have ever seen. So he's basically, I hear you. You want to slow this down on the Speedy Trial Act. You want to slow this down under CIPA. I think what they're going to do, because the judge isn't going to have any of that, by all accounts, is I think they're going to really delay discovery. And they're going to be in this position where the we know that James Comey has said, I'm going to bring motions. And one of the motions is related to whether the new U.S. attorney was properly appointed. But the
Right.
other is an obvious motion for vindictive prosecution.
Right.
And that they're going to say that we either win outright or we want discovery. And that's where the government, and we know this from other cases such as Abrego Garcia and other immigration cases, that um, the marching orders, I think, to the prosecutors are going to be, we are never turning over communications between the White House and DOJ, because they could just be horrendous in terms
Yes.
of what they said to do. And so
Right.
that's where I see the government trying to delay this even further, saying, you know what, Judge, we're going to appeal you. We're going to go to the circuit. We're going to go to the Supreme Court and try and get the case delayed past the January 5th date, because this team has to know, they have to really get up to speed. And if you don't have evidence, the best strategy, I mean, well, obviously the best, you shouldn't be on the case and you shouldn't have brought it, but it's avoiding the inevitable.
Oh, there are a few things that are interesting, more than a few things, but a few things that pop to mind immediately. First of all, you would think that the U.S. attorney would know the case, but she doesn't know it either,
Oh, of
really,
course not.
because she was brought in like 10 minutes before she went to the grand jury. So that's also beyond peculiar.
Yes.
And what is even more bizarre is the most important information about vindictive prosecution is a message that was inadvertently released by the White House that says has Trump saying, indict these guys, go fast. That's pretty compelling. I mean, the judge could even rule simply on that and say, I don't need a bunch of evidence. I'm already dismissing it. I know enough.
Yeah, look, the judge, let me back. Vindictive prosecution is a hard
Yes.
area of the law for the defense to win, and I would say rightly so. And the reason it, in my experience, I've never seen it succeed is because prosecutors, regardless, by the way, of party, this has nothing to do with that, whether it's a Republican or Democratic administration, you're bringing a case because it's righteous, you believe it's righteous, and you have evidence, and you're not singling the person out because of any animus towards them or because they asserted some constitutional or statutory right. You're doing it because of why you're at the Department of Justice to begin with. It's just how you're built. And
Yes.
could you imagine? I mean, I just can't even imagine I mean, I served under Republicans and Democrats. If I had said to Larry Thompson, we're going to do this case, but it's because the person's a Democrat, I mean, he'd be like, you're fired.
Yes,
Like, I mean,
exactly.
it's just
Right.
not, it's not possible.
We don't see vindictive prosecutions succeed because we don't usually have vindictive prosecutions. This
Exactly.
is the one White House where this is
Well,
clearly it.
yeah, so the judge could obviously rule based on the current facts, but a lot of judges, this is a tough area of the law. You want to build a record, and he could say, look, turn over the discovery. He may also be thinking, it could make it stronger for the defense, and thus I don't have to worry as much about the appeal. Like, let me have a full record, and let me hear, the government will make some argument about why it's not vindictive, and he's going to be like, okay, I want to assess that in light of all the evidence. In other words, I want to, in good faith, take your representation in good faith, and I'm going to look at the facts on the ground and decide whether that is, to use the phrase of Judge Immergut recently, is your position tethered to the facts or
Right,
untethered?
right.
And so I suspect that that they will that there will be this sort of dispute over discovery, and that is a battleground that the administration is not going to want to be on. because of what they're sitting on. And
Exactly.
it could just be this. When this happened, this whole case was brought. I said, this could blow up,
Yes.
and we could see the sort of communications, which are, I don't care about Mr. Siebert, my current, the person who I chose to be the
Yes.
U.S. attorney. If he's not indicting him, get rid of him and put her in until we find somebody who is going to indict. I mean,
Exactly.
we know that was the sentiment, and it may be that was written down. Now, obviously, we have as you pointed out, the DM to Pam Bondi that the president apparently thought was private, that is public. And I agree with you that if there's ever going to be a vindictive prosecution case that looks not just meritorious, but sort of like you look in the dictionary for what is
This is what
vindictive
it is. This is
prosecution.
what it looks like. Yeah.
Exactly. I mean, Abrego Garcia just got discovery from Judge
Yes.
Crenshaw in that case, which again is remarkable. But if this case is even stronger for a
Yes.
vindictive
Yes.
prosecution argument.
Yes. Now, a couple things. First of all, the defense doesn't necessarily have to wait for the vindictive prosecution dismissal hearing and that process. They can say, fine, we're going to maintain this, but in the meantime, let's go to trial. Let's just go to trial. And they could say, your case is so full of crap, and we'll talk about that in a moment, that we just want to get in front of the judge and in front of the jury. And maybe the judge will have a directed verdict or dismiss it outright. Maybe we'll be done with this in, 24 hours once we go to trial.
I agree with you. That did not seem to be their tack, the Comey tack. I was very interested in looking at for that issue and
Yes.
as to whether they said, you know what, we do have this very strong vindictive prosecution claim. We may have a very strong, but I think slightly weaker claim with respect to the appointment of Lindsay Halligan. But by the way, that they could win on that. I'm just saying that
Yes.
I think they're more likely to win on vindictive prosecution, because on the theory that if not here, when,
Yeah.
and um, but I thought they might. I think it is hard to do both when push comes to shove, because if the government slows down discovery on that and that goes up on appeal and there's all these issues, um,
Yes.
then remember the remedy for a vindictive prosecution is we want the case dismissed. But
Yes.
if you, so at some point that becomes moot. If you've gone
Right.
to
Because you're going to
trial
trial. Right.
and like, I mean,
Yes.
it wouldn't be moot if you go to trial and you're convicted and then you have vindictive prosecution.
Right.
But I don't think that's what's going to happen. I think
Right.
what's going to happen is at best, it's going to go to trial and the judge, just so people know, technically, when the government has finished its case in chief, like present their main case,
Yes.
the defense makes a motion saying that they haven't proved the case and that no rational jury
Right.
could reach a verdict of guilt. Some judges then say, I will take that and hold that and see what the jury does, but I may sort of overrule what the jury does. Other judges will say, you know what, that's absolutely right. I'm going to dismiss the case. And if the judge does that, dismisses the case at that point, that is not appealable. That is
Yes.
over. If the
Because that would be double jeopardy if they then came back and did it.
exactly.
And that may be politically safer, if you will, for the judge. I don't want to say that the judge playing politics, but he wouldn't have to be at loggerheads with the administration over this issue of executive privilege. And again, he wouldn't be subject to being overruled by, God forbid, the Supreme Court if it went that far. One
But he
thing,
also, by the way, he could take his cues from the parties. In other words, if the parties are saying, Judge, we want to pursue vindictive prosecution and delay the case, but I know you've decided your piece quickly, but the discovery piece now is going to go up on appeal, and we want that before the trial. I think
right,
he's not going to have a dog in the fight to say, look, if that's what the
right, he's going to
parties
have to go,
want.
right,
Yeah.
exactly. And we think, although we can't get into his brain, that Comey and his lawyer want to go this way because it will show that Trump has been vindictive. They have an interest in exposing Trump on a political, personal basis. It's not just enough for James Comey to say, well, they had a good faith belief, and look, there really wasn't evidence, and I got off. This is the point, to show that this Justice Department, this president, is completely out of control and is doing something that no other president has or would ever do. Is
I,
that a
I,
fair kind of assessment of
I,
what you think
I,
he's up to?
I do, and I think you can think of it both politically and legally, and this is an area where they marry. They're completely the same.
Right,
You could imagine, me being sort of a nerdy, lawyer,
right,
academic.
right.
I think of this as if there is a really valid, sort of platonic ideal vindictive prosecution case, that needs to be shown, and that is part
Yes,
of what the law requires to call out. And so
yes,
just as a legal matter, it's like it is not okay for the department to do this, and so it needs to be called out. And as a
exactly,
principled matter, it is
exactly.
true that by the same token, it works politically because it's like, the president's saying that's not what's happening. You have Pam Bondi saying, oh, no one's above the law. But if you can show that, by the way, I could go on and on and on about that statement and why it's like, of course, it's literally true. It's just as
Right.
inapplicable to this administration. But um, this is one where, yes, it could also show that is exactly what did not happen here, and we have it in writing.
Exactly. Um, Let me spend a couple more minutes on the Comey indictment itself, and then I do want to talk about Pam Bondi because that, in and of itself, was not just horrifying, but I think it speaks to how contemptuous this administration is of the rule of law and the degree to which they are eviscerating the first branch of government, which is Congress. The indictment, we think, and again, we think, rests on a supposed lie that James Comey told in 2017. And we'll get to why that really isn't the basis of this, but in which he said, I never told anyone to in the FBI to leak. And we think the Justice Department has in mind a guy by the name of Richmond, who was a sort of a special counsel brought into the FBI. Well, it turns out there's two problems with that. One, Richmond has already told the FBI, no, he really never told me. In fact, twice I know he told not to leak. So the very premise of what they have to say is a bold-faced lie. And secondly, as we were talking, that's really not the lie that this case has to rest on. It has to rest on a very indisputable statement, which he says, I'm not changing my testimony.
Yeah. So this is one where
Well,
everyone just bear with me for a moment.
yes,
Normally, in a false statement or perjury case, an indictment specifies the precise language that
right,
you are saying was false.
is false.
And by the way, the defendant is entitled to that. And here, James Comey will get that and if it's not from the government, the court will
Yes.
direct it in what's called a bill of particulars. That did not happen here, which is why, Jen, when you say, well, we think, and we were all playing this game of like, well, what is it? What is it they're really saying here? And James Comey's lawyer, Pat Fitzgerald, made that point in court saying, we still don't even know precisely what's being alleged.
Yes.
And then I was thinking about this, and a friend mentioned this, which I agree with. Why is it? Why did they not allege this? Now, the indictment says James Comey falsely said that he did not authorize anyone at the FBI to leak information while he was the FBI director. And you are right that that is something that James Comey said in 2017. 2017, stay with me. 2017, that testimony in 2017 is not what is charged. It could not be charged because there is a 5-year statute of limitations, meaning that if you
Exactly.
wanted to charge that, it would have to be by 2022. I usually don't do math in public, but I'm going to try and do the best I can. So instead, they're relying on a statement that we believe was made during testimony in uh, 20,
2020.
2020 during the pandemic. James Comey is at home testifying from his home in the Eastern District of Virginia, and the senators are in Washington, presumably, or someplace, and they're asking questions. And Ted Cruz, senator from Texas, confronts him with the information from 2017, and James Comey says the following. He doesn't say, I never authorized somebody, et cetera, et cetera. He says, as summarized by you, I stand by my testimony. Now, the indictment says that doesn't say that's the falsehood. The indictment says that the falsehood is the statement in 2017. The statement in 2020, I stand by my testimony. How is that false?
He is. He is standing by his testimony.
Right. In
Exactly.
fact, right. In fact, one, how do you ever say that is false? And so that is technically what is wrong with this, which is that that is not a falsehood that could that I mean, I just don't even see how how you begin. But then, even if the government gets through that, they have the problem that you mentioned, which is their what appears to be their only witness. We'll see whether they pull a rabbit out of the hat.
Yes.
But Dan Richmond is reported to have told the Eastern District of Virginia that is wrong. I was not told that by James Comey. In fact, I was told the opposite by
I-
James Comey. So if that is your star witness, just to be clear, the court will dismiss the case.
yes. So let's say, for sake of argument, that eventually he gets what's called a bill of particulars. In other words, we need to know, like, what the hell
Yep.
you're talking about here. And they are forced to confess, yes, it is this statement, and they have to submit the videotape or some other record of it. At that point, could Fitzgerald go to the court and say, you can't base a false statement on this because, in fact, he didn't change his testimony? Could the judge rule on that specifically and this whole nonsense be thrown out at that point?
Yes, that is one where the judge could say, I want to see the grand jury minutes. I want to see how they were
Yes.
charged. And remember, they can't go back to the grand jury to fix it because they're out of time. The statute, if this indictment's thrown out, unless you can somehow relate it back, they're done. And so what exactly the grand jury was told, because I strongly suspect this nuance was not presented to them, and it was
Yes.
presented as if this was the 2017 statement. And why do I say that? Because if you look at the language of the indictment, it says James Comey was
Yes.
representing the 2017 statements, but and maybe I'm missing something from the
But
2020
he didn't.
testimony, but he just says, I stand by it. That is not literally false. And
False. It
there
can't be
is,
false
right.
unless he did change it. I mean, if he said that and then he changed his
No,
testimony, I guess
Andy,
it would be false.
if he said I stand by it, but he knew at the time he didn't stand by it, they're never going to have evidence. I mean, this is now we're talking about ridiculousness, and Jen, we're talking about the FBI director,
Exactly.
and
And that
so
they insisted upon going forth with this pile of crap. That's the technical term. Because the president of the United States is a psychotic, vengeful character. And that's what is so patently absurd and different than anything else. There's no comparison to this kind of case. People are saying, well, the Justice Department has been weaponized by other. No, This is sui
This,
generis. This
this
has
is
never happened before.
this is the answer to the people who are out there who are cynically saying, "Oh, this happens all the time, and isn't this just what Democrats do it now? Republicans are doing it. It's just tit for tat." First of all, two wrongs don't make a right, even if that was true. And I would encourage people to look at the facts.
Yes,
Facts matter. Labels and adjectives are not facts. Um, you know, when you look at the Biden administration, ask yourself if they're weaponizing the Justice Department, how is it that they prosecuted Hunter Biden, the president's own son? How is it they prosecuted Senator Menendez, a sitting senator of their own party? Um, this is something that, as somebody who is a career person, any lawyer worth their salt, a prosecutor or a defense lawyer, knows this is garbage. That is
yes,
not how the system's built. I am not saying that there aren't occasional areas where you go like, what happened there? And the reason that you think, okay, there's a problem with that is because it's so aberrational. And you think,
yes,
oh my God, that shouldn't have happened. The reason you're concerned about what Jeffrey Epstein getting this sort of like real slap on the wrist in Florida is because you go like, wait a second, that's not normal.
right.
That of course can happen, and I'm certainly not here to say it never happens. That is not license for the president of the United States to say, now I'm going to weaponize the Department of Justice. The last time that happened was when you had Richard Nixon, and that is the reason that you have the policy of the White House not communicating with the Department of Justice is precisely that you don't want the president going, you know what, I want you to open a tax investigation on Jen Rubin. And so here it is just out in the open. And if you don't think
Right.
it's out in the open, the president has called for the jailing of a sitting governor and mayor. Um, you
Exactly. He
know,
does this all the time. I mean, that's the other sort of problem with this is that he keeps compulsively telling on himself that this is his mindset. I'm the vengeance. I'm revenge. I want this one jailed. I want Hillary Clinton jailed. I want that one jailed.
and
So
look, and
I
I
think
will
we
say this is to be a nerd, shame on the Supreme Court of the United States because you can
yes,
trace this back to
absolutely,
the Trump versus United States presidential immunity decision,
absolutely,
where part of that decision said we're getting rid of the part of the indictment, which is the president's communications with the attorney general, even
absolutely.
where the allegation is that the president wanted them to open a bogus, fraudulent criminal investigation. And he said, no, those communications are off limits. Those have been given exclusively and preclusively by the Constitution, which, by the way, if somebody could show me the language in the Constitution where that is, because I'm not seeing it. And that gave license to this idea, which is how are you actually going to prosecute this if you were ever going to say this is wrong? There's no deterrent to
Correct,
the
correct.
president thinking I can't do this, not only because I don't think he's thinking about morals and principles. I'm not doing it as a matter of self-preservation. But he
Yes,
doesn't have to worry
exactly.
about self-preservation because you have a Supreme Court saying communications with DOJ are off limits.
And we were so naive as to say, well, this means he could fabricate evidence. This president doesn't need to fabricate, he just has no evidence. So, therefore, the communication is not that, oh, we'll come up with something, we'll give you something, you won't embarrass yourselves. It's okay, we have nothing, just put something in the paper, tell the grand jury, whatever, just go to
Uh,
trial.
let
And
let me
that's
just
the
give
hard part.
let me just give one slight caveat on that, which is, we don't know. All signs are that everything you're saying, Jen, is completely right. And
All right,
and
fair
I just,
enough. Fair
I
enough.
think you are going to be proved totally right. And the one thing I think is sort of without question right now is it's never going to be proof beyond a reasonable doubt to 12
Oh,
jurors. Um,
yes.
but I guess having been a defense lawyer and a prosecutor, maybe they have something. It
We'll see.
nothing about
Well,
what we have seen so far in any
correct.
way suggests that. but I just want to put that out there
Absolutely,
that it
absolutely.
may
Based upon
be.
what we currently know. Thank you,
Yeah,
Counselor. This is why you were the General Counsel for the FBI. All right, in our remaining moments,
sure.
Pam Bondi. She went up to the Hill. She was asked a series of absolutely predictable questions about weaponizing the department, about her oversight, a whole ream of questions. And she not only didn't answer them, she instead insulted and barked back at the senators as if I would say, Mr. Weissman, what is your name? And you said, oh, you're a crappy interviewer. I mean, that's the level of conversation it was, or even worse. Well, didn't
Oh,
you
it was
give
worse
money
than that.
to Jeffrey Epstein, which is nonsense, as she accused, someone receiving money from donations. What the hell was that all about?
So I described it. You can't say that Pam Bondi went up there and testified. You can
Yeah.
say that she went up there and gave a performance because, so one, it was so offensive to me because when you're in the executive branch, you may not like congressional oversight. You don't, if you really don't like congressional oversight, don't take the job. That is part of what it means to have three branches of government. And so
Right.
that's sort of step one. And I don't mean, I know that may sound very naive and, but it's like, I just don't want to normalize what's
Yes,
supposed
exactly.
to happen. And again, by the, just to be fair, like that that is something that is happens in Republican and Democratic administrations over and over again. It is a bipartisan issue. Obviously, some do it better than others. Some are more responsive than others. Um, it is not. It is playground childish retorts to have Attorney General of the United States have OPPO research as their
Yes,
binder, as opposed to having their binder be filled with the answers. To
correct.
say, you're asked a question about, let's say, Mr. Homans and what happened to the $50,000. And
Exactly.
your answer is, just give an example. Didn't you lied to the public about your military experience? Or
Right.
didn't you, aren't you friends with someone who who socialized with Jeffrey Epstein, or you took money from that person? Let's assume that all of that is true. That doesn't answer the questions. This is like
Yes.
you're asked a perfectly good question, and Senator Whitehouse asked a question that I thought the non-response spoke volumes, which was,
Yes.
"Have you seen a photo that
Yes.
there were allegations of it? It may or may not be true. I have no idea whether it's true or not. That of sort of fairly salacious photos involving Donald Trump and Jeffrey Epstein, and basically the attack was, um, you know, you're ugly. It's like it's it's where you sit there and you want to go like, okay, let's assume that all of those attacks are true. Let's assume everything in your Oppo research is right. That I am a terrible, horrible person.
Right.
Now answer the question,
Question. Exactly.
right?
Exactly. And we, there are a couple things wrong with more than a couple things. First of all, this is the Attorney General of the United States, and she is essentially saying, if you are someone testifying under oath, you don't have to answer questions. What does that say to the rest of the world? Every prosecutor, every witness. It's basically, we don't have a system of justice where you have to answer questions under oath. So, problem number one. Problem number two is they have essentially said there's no Congress. We don't recognize a Article 1 body. We don't have to explain ourselves to anyone, and we're not going to. And that, ladies and gentlemen, is what dictators do. They say they're not
So
responsible to anybody.
my big take home from that point is we know who Donald Trump is. We know who Pam Bondi is. We know who
Yes.
Kash Patel is. I did not learn a single thing new about them. I do not respect the way they are conducting themselves in terms of understanding what it means to be a public servant. The part that is the complete abdication and erosion of checks and balances is that the Republican part of the Judiciary
Yes.
Committee did not say, hold on there. You are not like, your answer to my colleague, the senator from Vermont, answer his question. Let me give you one quick example of this. There was an argument in the Supreme Court where Justice Kagan asked a question and got a very, very dismissive answer from the Solicitor General's office. And Amy Coney Barrett stepped in, and I'm just going to
Yes.
paraphrase it to
I remember.
say, I'm sorry, is that your question? Is that your answer to her question? Is that the way you are going to respond to her? And to me, that was what you expected to hear from anybody thinking about the role of the court, the role of the Judiciary Committee and Congress was, and I gave her a lot of credit to be like, that is not an acceptable way to answer here. I know you don't think you're going to get her a vote. That is irrelevant. Like
Yes.
you answer the question and you are respectful. And I, whose vote you are looking for, am insisting on it. And to
Yes.
me, that, there are different committees in Congress. And when I was the general counsel of the FBI, I had to prepare various people to testify. I was very often a backbencher to, on those things. And one, you always came with answers and you came prepared and you tried to deal with their questions. As I said, sometimes it's more painful than not. But certain committees were known as being just having very serious people and more of a bipartisan
Right.
uh, flavor and makeup. I'm not trying to be like a halcyon days and everyone always got
Right. Right.
along, etc. But the Judiciary Committee, like the intelligence committees, um, was one of those places. And to see that happen, to me, it's like yet another domino has fallen where
Exactly.
it wasn't about Pam Bondi. It was
No. Yeah.
really a hearing about, was the institution going to have any self-respect in terms of their role as three branches of government? Because right now we have the lower courts functioning.
And that's it.
That's it. I was trying to think
That's
of, that's
it.
it.
That's it. Um, well, I think if she gets away with this, and it looks like she is, we can forget about any oversight for the next however many months it is till January of 2027, when potentially a different party may hold at least one house of the Congress. Because why would any other member of this administration treat any other committee any differently if the Attorney General can get away with this? And
I agree.
Republicans should be held accountable for that. And frankly, when they start running in 2026, Democrats have to point to these Republicans and say, you are a doormat for a despot. You are going along and rubber stamping every crackpot from RFK Jr. to Pam Bondi to Donald Trump. And you don't deserve to hold the office of U.S. Senator. You've
Uh,
abdicated your role.
and I do think that that is going to have resonance in terms of the American people, because there are. I mean, I guess I still have this faith in that. We do have a country that's elected really wonderful presidents, and wonderful people in both parts of the Congress, and I think the country also does have, in spite of the president thinking that they don't care about process, you look at the polling and it turns out they do. Um, I'm going to tell you a really quick story that I may have told you in the past, but when I was a young lawyer at a law firm, we had a death penalty case. And we ended up winning in the Georgia Supreme Court. And we thought we'd have to win in the federal court later. And the Georgia Supreme Court said about this person facing the death penalty, and he had an IQ that put him in the range of, at the time, was called mentally retarded. That's not a term we use anymore, but at the time, I'm old, that's the term that was used. and the Georgia Supreme Court said, essentially, we are tough on crime. We don't tolerate crime, but we are fair. And we are not going to kill somebody with this mental condition in the state of Georgia. So this would be a violation of our Georgia Constitution. And I think the analogy is, I think that people do care about, yes, you can get people out of the country who shouldn't be here, but there is a process to do that. You have to make sure, by the way, you're not deporting an American. That if you say they're a gang member, they're entitled to prove no, they're not. I mean, it's like I just think that people do have a sense of that, and they're going to care about substance, which is they might actually care about vaccines or cures for cancer, or actually having science based on, wait for it, science, and you know, not based on like mesmerism, and other crackpot ideas, and that you should actually have somebody running the Department of Health and Human Services who actually has a medical degree and
Right.
understands science, and listens to scientists. So I just think all of that, whether it's substantive or whether it is sort of a fundamental feeling about due process, that is going to resonate. And I also think the more people can say the words Jimmy Kimmel, the better,
Yes, exactly.
because people
Yes, that
actually
does resonate.
understand First
Right,
Amendment. And
right.
the president has a wonderful way of changing the topic so often.
Yeah,
The Jimmy Kimmel thing was a big black eye.
it really
And
was. It
and
really was. Yeah,
that's not,
and
people shouldn't move on. It is like
absolutely.
you have to ask yourself what is going on there is what is going on in all of we're all Jimmy Kimmels.
Yes, exactly. Exactly. So I think we've got the slogan for 2026. We're all Jimmy Kimmels. Facts have to be tethered, law has to be tethered to facts, and science should be based on science. That sounds
I
like a
love it.
winning plan.
Anyway,
I think we've
sorry to be
got
on
it.
my soapbox, but it's like, it's like
Absolutely.
it everything's so momentous these days that it really does cause you to sort of, or at least me at least, to sort of go back to like we have
First
got to have
principles,
exactly.
basics. Absolutely. Absolutely. Andrew, it is always a delight, even when we're talking about the downfall of Western civilization and the erosion of American democracy, because I actually do have faith that we are beginning the comeback. And in any case, it's always a delight to talk to you. So thank you once again, and
You're
we'll see
welcome.
you next time.
Take care.
You too.